Hello, welcome back. It's Roger Royce with the 10,000 Startups podcast. I'm a partner with Haynes Boone in Palo Alto. I do emerging growth and venture capital. And this is our weekly podcast on legal issues relevant to startup companies. And today we're going to talk about something that you may or may not heard of called the Foreign Corrupt Practices Act, which is much broader than the title might imply. And given just how international the world is, and especially how Silicon Valley is, we just run into this issue all the time. It pops up where you might not expect it. And I think as we'll find out, it's a little bit unique to the United States. So our speaker here today is Kit Addleman. She's a partner and a powerhouse lawyer in securities enforcement defense, and has a nationwide practice advising public companies, officers and directors, advisors, funds, broker-dealers regarding securities investigations, as well as governmental investigations generally. She has successfully defended clients in civil and criminal investigations and litigation by the SEC and Department of Justice, and advises clients on securities regulations and compliance. And I guess one of her biggest areas here is Foreign Corrupt Practices Act, including allegations of accounting fraud. And Kit, thanks for being here. But when I first heard about FCPA, I thought accounting fraud is that, and I notice that's part of what you do. But maybe you could give us a little bit better and bigger explanation of what this law is.
Gosh, Roger, thank you for asking me here today, and thank you for giving me an opportunity to just talk about the FCPA, as we call it. Really, there's two components to it. One of it is really the bribery piece, right? Foreign corrupt payments. And the other component is one of accounting. That is, if you make a payment to a foreign official, whether it's a bribe or otherwise, you had better properly account for it. And the accounting parts of the FCPA have been used with respect to other kinds of accounting violations. But for purposes of today, we'll really just focus on the anti-bribery piece, which prohibits the payment of anything of value to foreign officials that help retain or obtain business. It applies to U.S. companies and U.S. persons in connection with the payment of bribes. I think the key points that we'll talk about really are the payment of anything of value, which includes more than just cash, and to a foreign official, which can be more than just the folks that we ordinarily think of as foreign officials, ministers and deputies, but it can also include customs officials, members of a parliament or a Congress, candidates for political office, policemen and military officials, ruling families in countries like Saudi Arabia, where there are still individuals in those ruling families. And then for getting or obtaining business can be not only, as we see it, a contract for some sort of service, but also getting relief from something like, a relief from a tax obligation or some other thing which benefits the business. It does require an intent component. Did you intend it to be a bribe? But the problem with this is, with the optics of making payments to foreign officials, even if you didn't intend it as a bribe or to help you get business, that is the way that the government officials, the prosecutors, are going to see it.
Gotcha. Now, so let me just kind of get the elements. So it's a U.S. company, and it's a bribe, basically a payment to a foreign official in order to get some sort of advantage or something in return. And what about like all of the companies I seem to work with? They have these foreign affiliates all over, and the question always comes up: well, gee, is my subsidiary that I own 100% of over in a different country? Are they subject to this law too?
They are, right? Subsidiaries' conduct or misconduct is tied to the public company or the private company in the U.S. And there is a distinction here in that the SEC can only take action with respect to public companies, but the DOJ with respect to private companies. So even if you're not regulated by the SEC and you have a subsidiary overseas, you need to make sure that that subsidiary, even if you don't own 100% of it, Roger, you might own less than 100%, but you can still be responsible for their activities. The same thing is true with respect to even distributors or third parties that you've engaged to help you do business in that country. If they are engaging in violations, you as a U.S. person and a U.S. company can be held responsible for violations of the FCPA.
Okay, gotcha. So very broad. Now, I understand this law was passed in 1977, and I remember hearing about it as an undergrad in college. But I've only really started hearing about enforcement about the past 10, 12 years. Why is that?
I think we would say one is the sort of understanding of bribery payments as an international or global concern for countries, particularly third world countries, as corruption that impedes business growth, poses sort of legal and reputational risks in the countries. But it can facilitate, the anti-bribery laws can facilitate the idea that development priorities in those third world countries should be about improving the business in those countries, or the standard of living in those countries. Oil and gas entities are a really good example of that. Where there's high corruption in some countries that are very oil rich. If you're paying people bribes in order to get business there, those individuals are getting the bribes, those individuals are being benefited, but none of that money is going back into improvements of the country, such as infrastructure or clean water, those kinds of things. And so the emphasis on kind of human rights that has taken place over the last 15, 20 years has increased the focus on the FCPA. But I would also say it's the prosecution side using an old tool to enforce the law, and realizing its importance.
Okay, that makes sense. It's interesting how just how times change. Now, one of the complaints I've heard about FCPA forever from companies, and I've heard companies publicly say this, and I guess experts say it now too, is that, gee, this isn't really fair because what you've just made illegal is just business as usual in a lot of countries. And my competitors, who are not U.S. companies that are trying to get contracts in those foreign countries, they don't have to comply with a law like this, but we do, and we're losing out on that business because of it. I'm just curious as to how you feel about that argument. First of all, do you agree? Does it put us at a disadvantage?
I would have agreed 20 years ago when I was even at the SEC, to say that it was a little unfair that the U.S. not only had this law, but was making enforcement a priority in this area. But now more countries are passing laws, and we're going to talk, I hope, in a few minutes about the UK Bribery Act. But there are other countries who previously had a lot of corruption that now have passed their own laws. I think Brazil is a great example of that, where they have passed an anti-bribery and anti-corruption practice. The reach of the U.S. Law, so anybody who's not only a U.S. company or U.S. individual, but doing business in the U.S., can also subject them to the Foreign Corrupt Practices Act. And the same goes for the UK Bribery Act. The reach is pretty extensive now. So many companies that are doing business in countries where we have these anti-corruption and anti-bribery laws have to be more and more focused, not just on the US law, but on the law globally.
Well, that's really interesting. So this is something that's being adopted around the world. I guess we lead and the world follows in this space.
I think that's true. That's true in this space and so many others, I would like to think.
Yeah,
But yeah, we are seeing it more and more, particularly in countries where the bribes are at lower levels, meaning, the customs officials or the, on the ground police officers and tax employees, those kinds of things.
yeah. Okay, interesting. So let me kind of continue with that. Does it make a difference where we are doing business then? Like, for example, we all feel like doing business in Canada is, it's like Canada. So do we need a policy if all we're doing is Canada and not someplace like China, we'll say?
Yeah, I mean, it does make a difference. I would say you need a policy regardless of where you're doing business if you have any international business. But where you do business will decide how significant that policy is, right? How detailed it is, and how much you have to do to make sure that you're monitoring and enforcing it. So there's this wonderful tool called the Global Transparency Index. There's a website called transparency.org that measures the corruption perception, meaning how we perceive that country to be in terms of corruption. It also indicates, as I mentioned, whether the corruption is at the highest level, where I would say, for example, China, where the payments are being made at higher levels, versus Mexico, where the payments are about, can you get your electricity turned on? And you have to make a payment, a bribe, in order to get that thing which you're already entitled to. And that's called a facilitation payment. A lot of people with their hands out in some of those poorer countries, whereas in others, again, China being example, Nicaragua, Venezuela, some of those very high on the corruption perception index. The companies, or I'm sorry, countries are ranked 1 through 180. Least risky countries, as you mentioned, Canada is among them. Denmark is the least corrupt at number 1. Actually, all of the Nordic countries are 1 through 4. The US is at 20, I think, and the UK is at 20 and the US at 24. But the highest corruption index, Somalia, South Sudan, Syria, Middle Eastern countries. So where you're doing business, if you are doing business in the energy world in the Middle East, you need to be very focused on anti-corruption laws and policies and procedures to prohibit that, and monitoring and enforcing and those kinds of things.
Yeah, I get it. The US is 24. That surprises me. You'd have thought that we'd be higher, but oh well.
Yeah.
You said something else really interesting. You use this term facilitation payment. So is that illegal if I'm entitled, if I'm entitled to electricity in a country and I just have to pay somebody to get the thing I'm entitled to? It doesn't feel like a bribe to me. It feels like I'm just getting what I'm supposed to have.
Yes, if it's a small payment, using that electricity example, you have to pay an extra, $20, even $100, to get the company or the government process to work, to get that thing you are already entitled to. And really, that is key, Roger. Am I already entitled to it, or am I asking for something extra? That's I'm asking for the turning on of electricity. And frankly, I've already paid the bills or made the down payment or filled out all the paperwork. That qualifies as a facilitation payment. And in the US, that small facilitation payment is not a violation of the law. In
Mm.
other countries, the United Kingdom among them, that is still a violation. Now, whether they will enforce it has everything to do with the size of the bribe, the frequency, and who is getting the bribe. So if it's at that low level, again, if it's a small dollar amount, it's unlikely that that's going to be prosecuted in the UK, using our colleagues in the UK office to understand that a little bit better. But if they see a continuing stream of payments at those lower levels, even in smaller amounts, the frequency of that could lead to prosecution.
Yeah, interesting. What other kind of things would lead to prosecute? What kind of payments are we concerned about, or what's the government focusing on? Is another way of saying it when it comes to FCPA.
Yeah, I would say focus right now in the US and frankly in other countries are around third party intermediaries. We talked about subsidiaries, but also all of those distributors and retailers, others, depending on the kind of business that you're in, you may need to have a local outlet, a local authority doing business with the government and making sure that those third parties understand that they can't engage in bribery on your behalf is a big deal. If you hire a third party entity because they have ties to a foreign official, and you're paying, for example, the governor of some Mexican state, his family member to do business on your behalf, that could be a violation, and we see a lot of those. A lot of the cases, even where the allegation is that there's an actual bribe, often the charge is for the internal controls, accounting provisions, because it wasn't properly accounted for in the system. I think the third area of current emphasis would be on travel, gifts, and entertainment kinds of things. We saw a lot with respect to World Cup tickets offered by companies in exchange for helping to retain business. You certainly can engage in entertainment of foreign officials if they're coming here to better understand your business, to do their due diligence, for example, before they engage in or get a contract with you. You can even pay for their flights. But engaging in some kind of over the top entertainment where you, oh, by the way, while they're here looking at your business in Dallas, and you pay for them to take a side trip to Disney World, or you pay, or I guess maybe, and you pay for the company, uh, uh, those individuals visiting the company to bring their spouse and their kids and other kinds of people with them um, to take a side trip, Disney World, Las Vegas, even New York City. Those have been charged as FCPA violations. And we see that a lot where companies are saying, is it okay if I bring this Saudi official over to look at my business? And oh, by the way, he's going to bring his wife. And oh, by the way, they're going to spend a couple of extra days. How much of that can we pay for, right? You can pay for the Saudi official's flight at a reasonable amount. The higher the official, the more likely you are to be able to pay first class, for example. But you can't pay for the wife, and you can't pay for the extra days where they just want to visit wherever your location is, or a side trip to another country as a connection to the US, those kinds of things.
I see. Wow. So you really have to look at this and keeping in mind for the audience, of course, we're talking just about government officials. So I don't want to discourage anyone who wants to take me to Disneyland, in other words.
That's right. Although, right, we have to keep in mind US bribery issues. In fact, there was a recent case the SEC brought about somebody who was engaging in US bribery and how that was not disclosed. So it was a violation of US bribery that was charged by the DOJ and charged by the SEC for failing to disclose it.
Yeah, and what you're saying about the accounting makes sense because I've never seen a financial statement that has a line item for bribes. So I
Right.
suppose that's how they get them if all else fails.
Yeah. Well, I would say the problem with the accounting issues is that people tend to write it out as something else,
Mhm.
right? Which is interesting, right? You're hiding what you're doing. The more open and transparent you are, if you actually said bribe because it's a facilitation payment and it's legal, then you're more likely to get by with it than if you put, um, you know, third party payment for expediting this or whatever. But it's misdescribed, right? That's the issue that the SEC and the DOJ are very focused on.
I see. Well, I know there's probably somebody out there in podcast land listening to this who is now saying, "Oops, you know, I might have I might have messed that up." And of course, the question is, what are the penalties like if there is a violation? I've heard they're large.
Yes, they're large and continuing to get larger. I do think in connection with the next administration, we may see less penalty inflation. But there are, I'll talk about the US consequences, fines against companies and individuals, up to $5 million. But there also are what they call, the disgorgement piece, right? How much business the company got as a result of that fraudulent payment can also be folded into those penalties. Criminal sanctions for individuals up to 20 years of jail time. If you have government uh, work that you do, for example, Department of Defense or otherwise, you could be disqualified from doing that. You could be, barred or revocation of those kinds of registrations, inability to do work in certain countries, not to mention just reputational risk, right? There's, you know, publication of announcements about the wrongdoing that occurred.
Yeah. Okay, so large amounts and fines and jail time possible in
Right.
egregious cases, I suppose. So then the obvious question is, well, what do we do to make sure we don't have this problem? And you mentioned policies and procedures. Is that enough? I mean, does that get us off the hook?
Well, it doesn't get us off the hook entirely. Policies and procedures are the first step. In the UK, a failure to have a policy and procedure would be a strict liability on failing to prevent bribery or failing to prevent fraud, which is in and of itself a violation that companies can be charged for. And we can talk a little bit more about that if you like. But the policies and procedures issue is first a statement by the company that says we don't engage in bribery. And for most of the companies that we represent, whether they're public or private, the statement is we don't even engage in facilitation payments. If somebody asks you for a big one we had was a trucking company that was going from the US to Mexico. And at the Mexican border, the customs agents would ask for a bribe to let them through. Well, the truck is entitled to get through, assuming they don't have, something wrong in their truck or whatever. But the issue was just occurring over and over and over, and it was costing the company a lot of money. So the idea that the company just had to say, no, we're not paying those anymore. The trucks would be sidelined briefly during a period of time when the government officials, the customs officials, were understanding we don't pay anymore just to get the work done that we're entitled to have done. Then stopped the bribes at that point. People no longer saw the truck with that name on it and assume that they're going to get a payment. So we don't even suggest that the policy provide for a facilitation payment exception.
Mm.
But the policy needs to have teeth to it, right? You have to implement it. You have to make sure that your third parties understand the rules associated with it. Maybe you even put in place some audit rights or audit procedures with respect to third parties to say that, we have the right to come in and look at your books and see who you paid. We want to see your check register. We want to see all of those things. So the implementation of it, training, all of those kinds of things are very important, as well as the policy. Now, I will say in the UK, I made the mention of the fact that, failing to prevent fraud or failing to prevent bribery is in and of itself a charge. There is a defense for the organization. So the way it reads is the commercial organization commits the offense if a person associated with it bribes another person for the benefit of the company or organization. And, that person associated is super, super broad. It is a strict liability offense, but there is a defense if the company proves that it had adequate procedures that were proportionate, that were committed to at the top level. There were risk assessments, diligence, communication, including training, and monitoring and those kinds of things. So it's a very important piece for the UK law to have that in place.
Yeah, so a company can't just close their eyes to it and not look, at least under UK law. Is the US similar or a little more flexible on that?
Well, it's not a strict liability offense in the US for a company to not have a policy, or for taking a failure to prevent kind of approach. I would say, however, that in most of the instances we have seen where a third party or an employee in another country, or even in the US, pays a bribe, it is rare for the company not to be charged. We would, we could talk about self-reporting if you want, but typically that's the reason we don't engage in self-reporting. When you find that you had a problem, you fix it and you move on.
Mm-hmm.
Uh, and unless there are certain other things that happen. But the US having a policy or procedure gives you the opportunity to argue for deferred prosecution agreements, non-prosecution agreements, lower charges, lower penalties, those kinds of things. So there's still a great benefit to having a policy and enforcing it.
Got you. Okay, well, I just have one last question. So we had an election recently. We had a big change now, change in presidential and now and also House and Senate are also the same parties. So we're all expecting, and we've been hearing about appointments being made all week. So we're all expecting a lot of changes in many aspects of government. So given a change in administration, what do you think is going to happen with enforcement of FCPA? Will that change at all, do you think?
Very likely we will see some changes in this area. I would say that FCPA enforcement has been fairly steady under both Republican and Democratic administrations. But the penalty issue and the impact that it has on companies and the shareholders and what the messaging is to the world, I think is going to change. I would suspect there will be much lower penalties. These, again, in the FCPA world, have just continued to ratchet up and up and up because the benefit to the company for making a bribe payment has been pretty significant. I don't see this as a priority area for the Republican administration. Look, it's just predicting. I don't have a crystal ball, that sort of thing. But I think there will continue to be the cases that are, I don't know, I would say sort of outright fraud, sham payments to officials. So we saw a Raytheon case recently, where there were bribes apparently paid to the Qatar military and other foreign officials through subcontracts with a supplier. Those kind of cases, I think we will continue to see, whereas more of the smaller cases, accounting fraud issues, simply around failing to, properly account for promotional expenses, for example, I don't think we will see as much of that.
Gotcha. Okay, well, thank you very much, Kit. This is Roger Royce with the 10,000 Startups podcast. I'm a partner with Haynes Boone. We've been talking with Kit Addleman, partner in our Dallas office, about Foreign Corrupt Practices Act and how it might apply to your company. So again, thanks for being here, Kit. With that, we're going to conclude the podcast and we'll see you all next week.
Thank you, Roger.